Federal Appeals Court just delivered a crushing blow to magazine capacity restrictions, permanently striking down a statewide ban as unconstitutional. But here's what nobody saw coming. A Supreme Court justice has now entered the fight with a statement that's sending shock waves through the legal community and could reshape Second Amendment law nationwide. What this justice revealed about the court's view on magazine bans is absolutely stunning. Before we get into the details, I need you to do something really quick. Smash that like button right now if you care about protecting your Second Amendment rights. It only takes a second, and it makes a huge difference in getting this information out to more people who need it. Also, if you're not already subscribed to the channel, hit that subscribe button and turn on the notification bell so you don't miss any future updates on your rights. Trust me, you're going to want to stay informed about this stuff. The Federal Appeals Court didn't just rule against the magazine ban. They issued a permanent injunction that prohibits enforcement forever. This means law enforcement cannot arrest, prosecute, or even investigate citizens for possessing standard capacity magazines in this state. The court examined over 2,000 pages of evidence, including testimony from 47 expert witnesses spanning constitutional scholars, historians, and firearms experts. What made this ruling extraordinary is that all three appellate judges agreed unanimously, which happens in less than 12% of Second Amendment cases, according to recent federal court statistics. The state claimed their ban would reduce violence, but the court found their evidence so weak that they called it speculative at best and contradicted by the record. The permanent nature of this injunction means the state cannot simply rewrite the law with minor changes and try again. The constitutional defect is fundamental. Legal experts reviewing the injunction noted it contains language so broad that it effectively prevents the state from enacting any magazine capacity restriction without completely new legislation that addresses the court's constitutional concerns. But here's what makes this permanent injunction different from every other magazine ban case you've heard about and why the Supreme Court justice's involvement changes everything. 100 million magazines in circulation. The court's decision relied heavily on one undeniable fact that the state couldn't dispute. There are approximately 100 million magazines, over 10 rounds, currently in civilian hands across America. To put that in perspective, that's enough magazines to give one to every third person in the United States, including children. These aren't rare collector's items or specialty equipment. They're standard factory magazines that come with firearms purchased legally every single day. The court cited manufacturing data showing that between 1990 and 2023, American companies produced over 4.5 million magazines with capacities exceeding 10 rounds annually. Gun owners don't seek out high-capacity magazines as some unusual modification. Manufacturers include them as standard equipment because that's what the firearm was designed to hold. The court specifically noted that the most popular handgun in America, the Glock 19, comes standard with a 15-round magazine from the factory. Restricting magazines to 10 rounds means banning the standard configuration of firearms that account for over 60% of handgun sales in the United States, affecting tens of millions of law-abiding gun owners. What the state tried to hide during trial was even more revealing about why their ban was unconstitutional. And it connects directly to what the Supreme Court justice addressed, the historical evidence disaster. The state had one job under the Bruin test: find historical laws from America's founding era that restricted magazine capacity or ammunition feeding devices. They brought in historians who searched through colonial laws, state statutes from the 1700s and 1800s, territorial regulations, and even municipal ordinances from the founding period. After examining thousands of historical documents spanning 150 years of American history, they found exactly 0 laws that limited how many rounds a firearm could hold. The closest example they could provide was an 1878 Massachusetts law about storing gunpowder in quantities over 10 pounds in residential areas, which the court correctly noted had nothing to do with limiting ammunition capacity in firearms. Their expert historians admitted under oath that magazine capacity restrictions are a 20th century invention that didn't exist during the periods relevant to Second Amendment analysis. The court pointed out that during the founding era, Repeating firearms like the Gerandin air rifle held 20 to 22 rounds and were known to the framers. Yet, no laws restricted their capacity. Even more damaging to the state's case, historical evidence showed that many states actually required citizens to maintain firearms with sufficient ammunition for militia service, directly contradicting the idea that capacity limits have historical support. The state's lead historian became so flustered during cross-examination that he admitted the 1878 gunpowder law was not a particularly strong analog, essentially conceding the state had no historical foundation for their ban. The appeals court absolutely destroyed the state's attempt to use this powder storage law as an analog. But there's one part of their reasoning that directly previews what the Supreme Court justice later emphasized. Self-defense encounters require capacity. The court heard testimony that fundamentally changed how judges view magazine capacity. Real-world self-defense data that the state desperately didn't want admitted. FBI statistics show that the average self-defense encounter involves 2.7 shots fired. But in 23% of defensive gun uses, the defender faces multiple attackers. Analysis of police shooting data reveals that even trained law enforcement officers have an accuracy rate of only 20 to 30% in high-stress encounters, meaning they miss 7 out of 10 shots. Citizens defending their homes aren't trained marksmen. They're regular people who may need multiple rounds to stop even a single threat. The court examined 127 documented self-defense cases where homeowners needed more than 10 rounds to stop attacks, including cases where citizens faced home invasions by 3 or more criminals simultaneously. The testimony revealed that reloading under stress is extremely difficult and dangerous, with studies showing it takes an average person 3 to 5 seconds to reload. Time that could mean the difference between life and death. Medical examiners testified that attackers high on drugs or experiencing adrenaline surges may not stop even after being shot multiple times, requiring defenders to fire more rounds than the 10-round limit would allow. The state's own expert witness, a former police firearms instructor, admitted under oath that he would never want to face a home invasion threat with only 10 rounds available. One case presented at trial involved a woman who fired 13 rounds defending herself and her children from 2 home invaders. And this specific case became central to an argument that the Supreme Court justice would later reference the state's failed crime data. During trial, the state presented what they claimed was definitive proof that magazine bans reduce gun violence and mass shooting casualties. The court examined their studies and found methodological problems so severe that they questioned whether the state's experts had any credibility at all. One study the state relied on counted any shooting with 4 or more victims as a mass shooting, but then excluded 68% of such incidents from their final analysis because including them would have contradicted their conclusion. Another state FUN study claimed magazine bans reduced shooting deaths by 11%. But when the defense's experts reanalyzed the same data using proper statistical controls, they found no statistically significant effect whatsoever. The court noted that states with magazine bans have seen no measurable decrease in overall homicide rates compared to states without such restrictions when controlling for population density and other factors. Perhaps most damning, the court found that the state's own internal law enforcement reports showed no correlation between magazine capacity and crime rates in the 5 years before and after similar bans were enacted in other jurisdictions. The state's criminology expert was forced to admit under cross-examination that criminals rarely comply with magazine restrictions and can easily obtain banned magazines through illegal channels or simply drive to neighboring states. What really caught the appeals court's attention was evidence that the state knew their data was flawed before they passed the ban. And this becomes crucial to understanding the Supreme Court justice's later statement. Compliance rates expose the problem. The court examined evidence that exposed a dirty secret about magazine bans that states never want to discuss. Compliance rates are abysmal. When Connecticut enacted their magazine ban requiring registration, they estimated 2.4 million magazines in the state would need to be registered. Only 38,000 were actually registered, a compliance rate of approximately 1.6%. New York's magazine restrictions saw similar results with estimates suggesting less than 4% compliance statewide. The court found this evidence particularly damning because it showed these bans don't actually remove magazines from circulation. They just turn millions of law-abiding citizens into technical criminals, while actual criminals ignore the law entirely. California spent over $24 million enforcing their magazine ban between 2016 and 2022. Yet, prosecutions for simple magazine possession occurred in only 89 cases, and 91% of those cases involved defendants already facing other serious criminal charges. The state's own law enforcement agencies testified that they lack the resources to enforce magazine bans and that such enforcement would require door-to-door searches that are both unconstitutional and practically impossible. Studies presented to the court showed that in every state with a magazine ban, the black market for standard capacity magazines flourished with prices barely increasing, despite the legal prohibition. These compliance statistics revealed something even more troubling that directly relates to why the Supreme Court Justice felt compelled to issue a statement rather than just deny the application silently. The Justice's strategic timing. The Supreme Court Justice didn't just deny the state's emergency application. The timing of this denial and accompanying statement was strategically calculated. Court watchers noted that the justice waited 11 days to issue the denial, which is longer than typical for emergency applications that usually get decided within 48 to 72 hours. During those 11 days, 3 other magazine ban cases reached critical junctures in circuit courts across the country. One in California, one in New Jersey, and one in Massachusetts. By waiting and then issuing a statement rather than a silent denial, the justice ensured that all pending magazine ban cases would have this guidance before lower courts issued their rulings. Legal scholars analyzing the statement's language found 17 specific phrases that directly quote or paraphrase the Bruin decision's most restrictive language about historical analogs. The justice specifically used the phrase serious constitutional questions, which appears in Supreme Court precedent only when the court believes lower courts have gotten the law wrong and need correction. Constitutional law professors have noted that this type of statement typically precedes the court granting certiorari in similar cases within 6 to 18 months. The justice's decision to write separately rather than letting the denial speak for itself signals to lower courts that continued enforcement of magazine bans may result in their decisions being reversed on appeal. This strategic timing tells us something crucial about what the Supreme Court plans to do with magazine ban cases in the very near future. And the implications are staggering for states still trying to enforce these restrictions. This Supreme Court Justice's statement is a clear warning shot to every state with a magazine ban. Your laws are living on borrowed time. As more courts strike down these restrictions in the coming weeks, I'll keep you updated on every single development because this fight is far from over. If you found this information valuable, do me a favor and hit that like button right now. It helps get this critical information in front of more gun owners who need to know about these changes. And if you haven't subscribed yet, make sure you subscribe to the channel and turn on notifications so you never miss an update on your rights. Share this video with every gun owner you know because this information is too important to keep to yourself. Thanks for watching, and I'll see you in the next one.